Hello, this is Matt on the Moon Lambo channel. Today, the SEC filed request for appeal in the SEC v. Ripple case. So this isn't the actual appeal itself, but procedurally, this is the first step in getting there. And of course, Judge Torres would have to approve this. So the big question on everyone's mind is, does this impact the legal status of XRP? Well, I'll tell you here at the outset, so as to not bury the lead, what I've seen from multiple attorneys is that the answer is no, this doesn't impact the legal status of XRP. I still have questions, though, and I've been asking attorneys questions for the last 2 hours, seeking to understand, and I still don't have perfect clarity, but this is a developing story. So just to be clear, at the time that I'm recording this, it's only been a couple hours since this news broke, and I've spent a lot of time on X, formerly known as Twitter, trying to wrap my little simple Moon Lambo mind around this, since I'm not an attorney. I only play one on YouTube. So I have questions, and by the way, just to be clear, me asking questions is not me assuming that the attorneys are wrong. It's me seeking to understand. Just there's no confusion about that. Sometimes when people ask questions on X, people take that as some sort of aggression. What? You don't immediately believe me without doubt? No. It's not that I'm doubting them. Of course, they must be right. There are multiple attorneys saying the same thing. I want to understand why, though, and I'm still missing some of that, so I'm just going to share with you what I know since it's a developing story, and as I receive additional clarity, I'll be happy to talk about it in future videos. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And by the way, funny enough, you know what was circulating earlier today? It was this beautiful little thing that you see on your screen here. It's fake. This is this SEC posting is fake, as attorney Hogan wrote here. But that being said, if the SEC is going to file an interlocutory appeal, I would expect it to be filed this week. And he said that this morning. So here, somebody faked it, just trying to trick the XRP community. You can see, for those of you looking at the screen, SEC logo at the top, U.S. Securities and Exchange Commission, with the headline, SEC decides not to file appeal. Funny, it's just funny timing, literally this morning. And then hours later, we find out, yeah, SEC, hey, planning to file something here. I mean, they did file a request for an appeal. That did happen today, but that's not the appeal itself. And so it's just funny, the timing on that. And look at what else happened. Before the SEC filed what they filed today, Judge Torres filed something, and this was shared by Eleanor Turt, who, of course, is a Fox Business journalist. She shared the screen grab, which is on your screen, from Judge Annalisa Torres. I'm not going to read it, but if you want to pause here and read it, feel free. But here's what Eleanor Turt wrote. New. Judge Torres says the court will seek to schedule a jury trial for the SEC/Ripple case in the second calendar quarter of 2024. Torres has ordered both parties to submit blackout dates for trial by Wednesday, August 23rd. See the full deadline schedule below, and it's on your screen right there. So this seems to be what prompted the SEC to file what they filed, which I'll get to in just a second here. But regarding what Judge Torres filed today, Attorney Hogan had the following to say. The individual defendant's trial will begin around May 2024. That means final judgment in this case won't be entered until late summer 2024 at earliest. Any appeal would go well into 2025. The glove is on the other hand now. Delays are good for XRP and Ripple. And by the way, I'll just note, when he's talking about appeal, that's through standard process. You've probably heard the term interlocutory appeal. And so, and that's ultimately what the SEC, it looks like they're going to be going forward with here, is an interlocutory appeal, which is basically an expedited appeal. Since the trial's not over, if you want an appeal, because normally appeal would come after the trial's over, if you want an appeal before that, you have to file what's known as an interlocutory appeal. And I don't think that this is going to be granted anyway, but the SEC's indicated they're going for it. But that's why Attorney Hogan said what he said. He said any appeal would go well into 2025. He wasn't talking about an expedited appeal, an interlocutory appeal. And Attorney Deaton also wrote this on the topic. I just did a live stream and said, if the SEC is dumb enough to appeal, and he put that part in quotes, and then he said, it's possible the SEC didn't have 3 votes to appeal, but I assume they could still ask by the end of the week and still argue it meets the reasonable time standard, but it would be really dumb of them. Of course, that's why I haven't ruled it out. So here you have it. Before before the SEC filed their request for appeal, Attorney Deaton said here that if the SEC does it, it would be really dumb of them. And the fact that it would be really dumb of them to appeal is the reason that Attorney Deaton had not yet ruled out that they might do that. Hours later, they did. My God, you can't make this stuff up. I absolutely love this. Is that not hilarious? My God, I love this. Shout out and credit to attorney James K. Filan for breaking this news just a couple hours ago. And he wrote the following: breaking. SEC files letter outlining its basis for filing a motion for leave to file an interlocutory appeal regarding programmatic offers and sales to XRP buyers over trading platforms and Ripple's other distributions. And then in a separate post, he wrote, the SEC seeking a stay of all proceedings pending appeal is not unexpected. And then he shared a post from December 21st of last year indicating as much. Now, there's also this. So Stuart Alderati, this is Ripple's chief legal officer, retweeted that from attorney Filan and wrote the following: the SEC does not have the right to appeal just yet, which is why they are asking permission to file an interlocutory appeal. Ripple will file its response with the court next week. Stay tuned. And so, I mean, the judge could approve this, but from what I've gathered from attorneys in recent weeks is that it's not probable that Judge Torres would even approve this. And so even if the SEC then appealed to a higher court and the judge was forced to, there are still problems that would be associated with that, which I've talked about on the channel, but I'm going to circle back around to that to talk about just a little bit later in the video. But it wouldn't go well for them, suffice it to say. And then there's this from attorney Jeremy Hogan. Once the news broke a couple hours ago that the SEC had filed a request for appeal, attorney Hogan wrote the following: and the SEC continues making questionable decisions, requesting an interlocutory appeal. Note that it is not appealing whether XRP itself is a security, just its losses on the programmatic and individual sales issues. And so I had questions on this because, again, I'm not an attorney, and this just broke within the last couple hours. Just like everybody else, I'm trying to make sense of this, and I've asked a bunch of questions. I don't have perfect clarity on this, but I will share with you the parts that I know. And people, you can always, if I get anything wrong, I'm operating in good faith. If I get anything wrong, you can always correct me in the comment section. I'm not offended by that. I like tactful responses to me. If I get something wrong, I'm human, so that can happen. Even though again, like I said at the outset of the video, I take all of the attorneys at their word when they say that the SEC is not asserting that XRP itself is a security. I understand they're not literally saying that, of course. But I had questions here, and I just need answers, that's all. And so I wrote to attorney Hogan. I haven't seen responses to this point, but again, this is all developing. I wrote, the Torres ruling on XRP programmatic sales is what led to XRP being a non-security and cryptocurrency exchanges relisting XRP. Isn't challenging programmatic sales the functional equivalent of challenging the non-security status of XRP? I need an adult. And I was actually, I realized shortly after posting that I was slightly off. The part where XRP was deemed to not be a security is actually, I knew it was on page 15. I didn't forget that part, so I went straight to it. This is the July 13th ruling from Judge Torres, and the crucial part, the most important part of this entire thing, it's on your screen right there, highlighted, and it reads as follows. From Judge Torres, XRP as a digital token is not in and of itself a contract, transaction, or scheme that embodies the Howey requirements of an investment contract. Rather, the court examines the totality of circumstances surrounding defendants' different transactions and schemes involving the sale and distribution of XRP. Okay, so I was thinking, as I was sharing that previous post with you, I was thinking this was intertwined with programmatic sales, and not exactly, but that doesn't still completely answer my question, as I'll explain in just a moment here. But I did want to cite that I needed a slight correction on that. So this is what's known as dicta. So this is Judge Torres stating a thing that she wasn't asked literally to rule on, not technically. She wasn't asked technically to rule on, is XRP itself a security? Is XRP a token that embodies so and so? But the reason that she was able to do it is because the SEC put forth what's become known as the embodiment theory, and they said that XRP embodies all of the effort, so on and so forth, that Ripple put forth, blah, blah, blah. You know the whole thing. So that's the reason that Judge Torres wrote on that. But that's actually outside of the section where she's talking about programmatic sales. So that's the part where I was slightly misremembering, but it's still, that doesn't change anything. I still have a question. Not a concern as much as just a question. I need clarity on this. So if you go to programmatic sales, this is the part that the SEC is pushing back against. And again, that is separate from the section I just showed you on page 15, where that shows that Judge Torres declared the functional equivalent of XRP is not a security. The programmatic sales portion starts on page 22. So you got to jump 7 pages in to see this. And the relevant portion reads as follows. And this is what the SEC is pushing back against. And this is why I still have a question you'll see as we go through this. The court next addresses Ripple's programmatic sales, which occurred under different circumstances from the institutional sales. The SEC alleges that in the programmatic sales to public buyers on digital asset exchanges, Ripple understood that people were speculating on XRP as an investment, explicitly targeted speculators, and made increased speculative volume a target goal. Having considered the economic reality of the programmatic sales, the court concludes that the undisputed record does not establish the third Howey prong, whereas the institutional buyers reasonably expected that Ripple would use the capital it received from its sales to improve the XRP ecosystem and thereby increase the price of XRP. Programmatic buyers could not reasonably expect the same. Indeed, Ripple's programmatic sales were blind bid/ask transactions, and programmatic buyers could not have known if their payments of money went to Ripple or any other seller of XRP. Since 2017, Ripple's programmatic sales represented less than 1% of the global XRP trading volume. Therefore, the vast majority of individuals who purchased XRP from digital asset exchanges did not invest their money in Ripple at all. An institutional buyer knowingly purchased XRP directly from Ripple pursuant to a contract, but the economic reality is that a programmatic buyer stood in the same shoes as a secondary market purchaser who did not know to whom or what it was paying its money. So she does mention secondary markets there. That's you and me, folks. So my question is, and again, this is not me doubting the attorneys. My question here is, even though she's not, or the SEC rather, is not coming out and saying XRP is not a security, Judge Torres is wrong on that. That's the part from page 15. They are challenging programmatic sales. Well, that's the part that matters to you and I, right? Because that's the part that occurs on secondary exchanges where you and I can purchase XRP. So my ultimate question is, okay, if the SEC's not saying that XRP is a security, I accept that, of course. But wouldn't this be the functional equivalent? That's my question. And it seems that the answer is no, but I haven't gotten the answer. I've asked multiple attorneys, but again, this is all developing, so there's only been an opportunity for this much time passed for to attorneys say what they wanted to say. So I'm not clear on that yet. I will have clarity, I'm sure, moving forward, so I'm going to have to circle back to the answer because I just don't have it right now. But like I said, with a developing fluid situation like this, it is what it is, and I just wanted to make sure I could cover the parts that I do know. Because, again, the most important piece of information here is that despite the fact that the SEC is pushing forward with this appeals process, XRP itself, they're not, this isn't some sort of challenge of the legal status of XRP. I do want additional clarity, which I don't have right now, but it is not a concern based on what I've seen from, John Deaton's Crypto Law Twitter account, from Bill Morgan, from Attorney Hogan. But I do still have this question about, the programmatic sales, and if something were appealed and successfully appealed by the SEC, what would the implications be? That's the part that I still don't have sufficient clarity on. And I'll move a little bit forward now. Oh yeah, somebody asked Attorney Hogan the following. Somebody named Dr. Giggles. What a fun name. Can the judge simply say no to hearing the appeal? Second Circuit, can they also just say no? And Attorney Hogan says correct. So I expect that Judge Torres is going to say no to this interlocutory appeal request. And then if it's pushed further, it goes to another circuit, they're probably going to shut it down there too. But even if they don't, the reason here, I'll just tell you now, the reason that it won't matter is because an Attorney Hogan has talked about it. Here's another attorney, Mike Selig, who's talking about this, and he wrote the following. This explains it perfectly. Even if the SEC were to win these issues on appeal, Judge Torres could determine that Ripple's programmatic sales and other distributions aren't investment contracts for other reasons. Judge Torres didn't address all prongs of the Howey test, with reference to these sales in her opinion. And so you may recall, if you might have caught this, as I was reading through the programmatic sales portion, at least a little bit of it, she cited one of the prongs of the Howey test, just one of them, not the other prongs. So if she's forced to analyze again, because there's a successful appeal on this one prong of the Howey test, she's just going to come back. You know what she's going to do. Attorney Deaton has talked about this ad nauseum. Should that occur, Torres will just rule on the other prongs and come to the same conclusion. So I'm not concerned about this. I'm certainly not concerned about this. And then I also wrote wait, actually, let me say this first. So Attorney Bill Morgan tweeted out the following on this topic. They actually waited until she made the pretrial orders to file a motion for leave to file an interlocutory appeal and to stay the pretrial orders she just made. Don't give them leave, Judge. Yeah, and so isn't that something? They waited until they were pressed. So I don't know if they feel backed into a corner, but Judge Torres filed what she filed today, and then hours later, the SEC pounces. Weird timing. And so part of what the SEC wrote, I cited in a post here on X. I wrote, when the SEC wrote, quote, the motion will also seek to stay the district court proceedings, including the recently entered scheduling order. Does that mean, end quote, does that mean pause the jury trial proceedings? Any impact on the Torres decision regarding XRP programmatic sales? And Attorney Morgan responded to me and said, yes, the SEC specifically seeks to stay the proceedings still live before Judge Torres, which is the case against Brad and Chris for their alleged accessorial involvement in the Ripple unregistered sales to the institutions, including the scheduling orders made today. And so my thought process at the time, that was one of my first comments, or questions really, after I read this thing. It's only 4 pages, and I don't feel the need to read through it, honestly. Just getting the perspective on what matters from attorneys, I think, is sufficient for the purposes of this. Although I do have the bad boy printed right here, and I marked up some stuff, but I don't think it's not. I think it's just going to be boring, and it's not good because most of it is not going to strike at the heart of the matter. So I just decided not to even read any of it. And so let's see. John Deaton's crypto law organization also responded to me and wrote the following: the trial has nothing to do with Judge Torres' rulings. She ordered the trial in her July 13th decision to decide the last narrow set of disputed facts related to the aiding and abetting allegations against Brad Garlinghouse and Chris Larson. They are requesting a stay of all other proceedings in Torres' court on the case, meaning remedies process, and the trial would pause. So again, that's what I was asking about, and the answer is yes now from Attorney Morgan and the crypto law here. The answer is yes, the trial would effectively pause should this occur. And then they say, just because they request a stay doesn't mean they'll get it. They might get a temporary stay while their petition for the interlocutory appeal is decided on, but that would not be a long one. In any case, if they hadn't asked for a stay, then their arguments for urgency in requesting the interlocutory appeal would seem pretty weak. In case you're wondering, a stay has no effect on Torres' ruling. All right, and then... oh yeah, and then there was also this. So then this is another post for me basically asking, okay, so Attorney Hogan says the SEC is not appealing whether or not XRP is a security, just programmatic sales, but isn't that functionally the same thing? If not, why not? And Attorney Morgan said, thank you. This all coincided with me getting ready and driving to work, so I haven't seen everyone's comments. Yes, just programmatic sales. The status of XRP as not itself a security can't be appealed in my view. So, okay, so I appreciate the response, but I've asked this to multiple attorneys and I'm not getting the answer that I'm looking for. I'm trying to find out, yes, I get it. You're saying it's not a security, but if you look at the assertions regarding programmatic sales, I want to know why there's no chance that would impact us if successfully overturned. That's the part that I want to know. That's it. That's the only piece that I'm really missing here, but it's an important piece, right? So I want us to all be able to understand that. And then there was also this. Yeah, and I wasn't the only one wondering this. There's a XRP community member, Yasin Mubarak, who wrote, it does not matter that the SEC is not appealing whether XRP itself is a security. If programmatic sales are found to be securities, the retail sector is effed. And he wrote that to Attorney Jeremy Hogan. And so... apparently we won't be effed if this happens, But that's why I'm saying, like, that's a legit perspective. That's a legit question. I'm trying to understand why that's the case. And that's the biggest question mark I have here. But again, I had a lot of good news for you and enough information to put out this latest Moon Lambo hot jam with the most important bits anyway. But I'll be happy to come back with another video in the future once I have sufficient clarity to let you know exactly what the answer is to that. But I'll go ahead and wrap up here. I'm really not worried about this. I doubt that this interlocutory appeal is going to be allowed to go forward. If it does, it's still going to be bad for the SEC. And this is why Attorney Deaton, literally hours before this all developed, he said that it would be really dumb if the SEC pushed forward with this appeal. And that's why, but he's also hilariously said, and that's why I think they might do it. And I'm paraphrasing now, but I showed you the actual post. Well, they did it. They're doing it. The SEC, God, what is wrong with these people? I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.